you listen to podcasts or read popular press articles about generative AI and the law, you may come away with the impression that there's some kind of collective delusion among the companies that are developing these tools and the lawyers who are advising them. Who in their right mind, you might think, could have thought it was okay to train a large language model on a data set consisting of a copy of the entire open internet, or something close to it, without asking permission of any of the people who wrote any of that stuff? Surely this is some kind of intellectual property violation of some sort, right? I am here to tell you there is no collective delusion. It is not against the law to train a large language model how life works, how language works, what the facts in our universe consist of, by showing it billions or trillions of pieces of pre-existing publicly available content. And you wouldn't want to live in a world where it was. Although the full legal analysis it takes to get there is complicated in some respects, the core principle underlying most of the key moves is pretty straightforward. No one gets to monopolize facts. Our intellectual property laws are not perfect, and they're in many respects counterintuitive. But on this issue, they've been both right and clear for basically a few centuries. If I write a book, there's a bunch of things you can't do with it, but also a bunch of things you can do. You can't take my book, make copies of it, and sell those for profit. But you can take the facts I recited in my book and say those to people you meet on the street. You can even write your own book using those facts. Just because I spent a bunch of time and energy discovering the facts and putting them together in one place doesn't mean that I can prevent you from repackaging them and expressing them in new and different ways to others. Let's make this a little less abstract. 87 years ago, the Hindenburg burst into flames and crashed in Lakehurst, New Jersey. There's a bunch of uncertainty around precisely how and why that happened. We know at a high level that the Hindenburg was intended to be a symbol of Nazi technological ingenuity and innovation under Hitler's reign, but there's no definitive understanding of what caused the fire that brought it down. In 1962, someone wrote a book called Who Destroyed the Hindenburg? And the book has a thesis, specifically that it was a sabotage, most likely perpetrated by a particular crew member who may have planted an explosive device for the purpose of impressing his lady friend, a suspected communist who was dedicated to exploding the myth of Nazi invincibility. The author developed that thesis by spending years reading the results of prior investigative reports, reviewing existing books and journals on the topic, and even interviewing survivors of the crash. 10 years later, someone else wrote a book called The Hindenburg. The author of that book reviewed the 1962 book as part of his process. And although the later book tells the story in a different way, it paints a picture of the same crew member carrying out the same sabotage for the same reasons. The author of the 1962 book was displeased, particularly when Universal City Studios optioned the later book and not his to be a major motion picture. And as one does in this country when one is displeased in that particular way, he sued everyone in sight. He lost, and it wasn't a particularly close case. He lost first in the lower court and then in the appellate court, and the reason he lost, to quote the judicial decision, is that factual information is in the public domain. It didn't matter that the second author had reviewed the first author's book as part of his process. It didn't matter that, as the court expressly assumed, the essential plot elements of the second book were the same as the story told in the first book. All that mattered was that the law doesn't allow anyone to monopolize facts. Think about how our creative and cultural world would be different if that were not the case. What if every time I wanted to take a fact I learned and use it in a new book or article or blog post or speech, I had to go negotiate a license with whoever wrote the book or article that I learned the fact from? The short answer is that there would be many, many fewer new books and articles and blog posts and speeches. And that result would be antithetical to the purpose of our intellectual property laws, which is precisely to foster more innovation and more output, not less. As the Supreme Court put the point back in the 19th century, the very object of publishing a book is to communicate to the world the useful knowledge which it contains. But this object would be frustrated if the knowledge could not be used without incurring the guilt of piracy of the book. Generative AI is a complicated technology. It does not always do what we want it to do, and we're still in the infancy of its evolution and refinement. But one of the core capabilities it offers is to see how someone recited facts about the world and then use those same facts in the service of new and different outputs. That is a feature, not a bug. It is a use of pre-existing content that courts have always said is okay, and it's a principle that makes our creative and cultural ecosystem richer, not poorer, in both the short run and the long run. No one gets to monopolize facts. That's both the actual rule and the right rule, and it's the foundational legal principle on which today's generative AI systems are based. Thank you.